For those of you who are joining our webinar for the first time, welcome. It's lovely to see you. We have got James Riley, who acted as solicitor for Mrs. X in the X and Kuoni case for Owen Mitchell. He's revealed exclusively to us this morning that actually he didn't kick the case off. It was Joe Dawson, now at Lee Day, who kicked the case off. So Joe presided over the failure of the case at first instance, then presided over the success of the case on appeal. We all know it's been a long time coming. Delighted to embarrass James again by saying that he's the Times Lawyer of the Week this week. He's begged me to tell you all that. Couldn't wait to publicise that. He's here to answer your questions, really. What I propose to do today is kick off by just asking James how Mrs. X feels about it. Obvious question. You know, is she unalloyed happy, or not so delighted that it took 7 years to get here? I'm going to take a whip through of the where this case has been and procedural history of it. Those of you who've heard me speak on X and Kuoni before will know that I'm quite critical about the procedural history of this, but I feel I have more to give, and I'm justified in giving a little bit more a rant, and after that I'll be quiet. Conor's going to take you through what happened in the Supreme Court. We're going to have a discussion, all three of us then, about what we think the meaning of this is, the ramifications for claimants and defendants. For what it's worth, I was just saying to James and Conor, I think this is one of the most important cases we have ever had on the 1992 regulations and the knock-on effects on the 2018 regulations. So worth having a discussion about that. We've had lots of questions from you all about the ramifications of it, what claimant firms should do, what defendant firms should do, what defendant tour operators should do in response to this. And I'm sure that James will have some interesting input on that as well. And then if we have time, obviously questions at the end. If you want to ask us questions as we go through, so if something occurs to you as we're talking, just put them on the Q&A. Every single time we do a webinar, I say this. If you've got chat, you want to say hi to your friends, you want to say hi to us, that's great, put it on the chat. If you've got questions, put them in the Q&A, because otherwise we might miss them if we're chatting amongst ourselves. Somebody always puts a question on the chat. That's okay, we'll pick it up if we can. If you want to anonymise, that's fine. You can ask questions anonymously. Otherwise, your name will go on the questions, and we'll read your name out potentially as being associated with the question. We are all friends here. We may not all act on behalf of the same entities, but we are all part of the industry, and this is a clarificatory judgment, I think, which in that sense should be welcomed by all of us. If we get time, I'll do a poll on, do we think it was success, do I think it was rightly decided? Everyone knows what I think about that already. But we may not get time for that. As I say, we've got loads to get through. Oh, I should say we're being recorded. So we will be here for posterity, and the webinar will be on the YouTube channel. Without any more, I don't think there's any more housekeeping. I'm sure that Emma will tell me if there is. I'm just going to turn to James then and ask you, yeah, you said that Mrs. X had given a quote about it. Presumably she's happy with it, but she spent 6-7 years in pursuance of, what is it, about £20,000 damages?
Yeah, so firstly, thank you, Sarah, and thank you, Conor, for inviting me to speak today. Shock, I think, was the immediate reaction from her, understandably. It's been a long fight, but followed by delight. She feels vindicated, I think. She's got the justice that she, in my view, she deserves in the end.
Okay. And is she, I mean, I don't know anything about her ongoing symptoms or ongoing states. I mean, is she as okay as you can be now? Is the removal of the litigation, has that helped?
Well, I'd hope that it gives her some closure now. She's working, but she's had to change her career. She's got a very supportive husband. So yeah, hopefully this now allows her to move on with her life as best she can.
Sure. Okay. Well, that said, we'll hear a bit more from James a bit later substantively. I'm going to mute myself because otherwise I'm going first. Conor, mute yourself. James, mute yourself. Everyone else needs to mute themselves. Right. Here we go. Where are we? Now, you've heard me talk about this before, very many of you, but I would just rattle through it again, just as a reminder for those perhaps who've not heard me ranting on the topic of X and Kuoni before. It's a really important case, this. It's to do with deliberate acts but it also rolls out on all of your other package travel cases. And actually, I think it's not just package travel cases that are affected by this case. We'll talk about that a bit later. So what are the facts? Well, the claimant was sexually assaulted whilst on a package holiday. 2010 holiday, so we're talking 11 years ago. She'd gone out with her husband in the evening. She'd come back, they got separated, he went back to the room. She was in the hotel grounds. Now, she asked, or she was offered actually, to find her way through the hotel grounds by a chap who was an electrician, although she said it was her understanding that he was a security guard. The judge at first instance rejected that and found as a fact that she knew that he was a member of maintenance staff. And that was important at the time, although it perhaps becomes less important in the light of what was then found by the Supreme Court. But in any event, this chap that the judge at first instance found she knew was a member of maintenance staff offered to help her find her way through the hotel grounds in the early hours of the morning. Sorry, let me go back. He took her into a room and he raped her. She made an immediate complaint in relation to that, and the case wended its way through various criminal courts, wended its way back to England, and she sued Kuoni. And there were a couple of causes of action. First, breach of the package holiday contract, because it was a package, and it was a standard clause of that package. We will accept responsibility if due to fault on our parts or that of our agents or suppliers, any part of your holiday arrangements booked before your departure from the UK is not as described in the brochure or not of reasonable standard. Now, you will immediately realise that that is effectively a mirroring of Regulation 15.1 as it then was under the 1992 regulations, which reads the other party to the contract is liable to the consumer for the proper performance of the obligations under the contract, irrespective of whether such obligations are to be performed by that other party or by other suppliers of services. Let's go back to the breach of contract. You can see that they accept responsibility due to fault on their own part, i.e. Kuoni, or that of their agents or suppliers. Go back to the package travel regulations. Liable to the consumer the proper performance of the contract, irrespective of whether it's to be performed by the other party, that's Kuoni, or by suppliers of services. So Kuoni accept responsibility for their own fault or agents or suppliers, and the package travel regulations impose liability for fault on the part of Kuoni or by other suppliers. Now, in this context, that took on a really important meaning. Kuoni defended the case not only on the basis that they themselves were not at fault and that their supplier, the hotel, was not at fault, but also on the basis of this defence under Regulation 15.2c2, which was also mirrored in the contract between the parties. So the other part of the contract is liable to the consumer for damage caused to him or her by failure to perform the contract or improper performance of the contract, unless the failure is due not to the fault of Kuoni, nor to another supplier of services, because such failures are due to an event which the other party, Kuoni, or the supplier, the hotel, even with all due care, could not foresee or forestall. So Kuoni's case was, it wasn't us, and that's accepted, it had nothing to do with Kuoni, not their fault. It wasn't our hotelier, nothing to do with the hotelier, not the hotelier's fault. So the hotelier had not failed to check out this guy's references, had not failed to supervise him properly, had not failed to train him properly. So it wasn't Kuoni's fault and it wasn't the hotelier's fault. And therefore, Kuoni said, well, the regulations just don't come into it because it's not us and it's not our supplier. And even if the regulations do come into it, we can rely on this defence because it's not us, it's not our supplier, and it's an event which, with all due care, neither we nor the hotelier could either foresee, because we didn't know who was going to do this, or forestall, because we couldn't have stopped him. So that's Kuoni's defence. And at first instance, before His Honour Judge McKenna, the defence succeeded. So His Honour Judge McKenna held that at the time of the assaults, the member of hotel staff wasn't carrying out the duties he was there to undertake. So he wasn't actually supplying the contractual services, which meant that he was outside the package contract. And furthermore, The defendant hadn't promised the claimant the services of an electrician. So even if he had been conducting the things that he ought to have been doing, his role was outside the scope of the package contract, because the contract was just for the provision of accommodation and flights and so forth. And the contract was not for electrical services, to put it in that way. Furthermore, the assault was not so closely connected with his duties that it was just to regard it as having occurred during the course of them, which is a sort of quasi-vicarious liability type test he's using there. So at first instance, the claim failed because although the judge at first instance believed the claimant in her account of the attack, he held that on legal grounds she couldn't recover because the electrician wasn't doing anything within the scope of the package, and it wasn't closely connected with his duties, so the hotel wasn't vicariously liable for him. Well, the case was appealed up to the Court of Appeal and failed in the Court of Appeal as well, with a majority decision, Lord Justice Longmore dissenting. The Court of Appeal held that the employee's actions in purporting to escort her through the grounds were outside his duties. So again, this is a reiteration of what the trial judge had said, that there are certain obligations under the package travel contract, and escorting someone through the grounds is not one of them. Furthermore, and alternatively, and this was what raised eyebrows in the legal world when this came out in the Court of Appeal, the tour operator was only liable for the acts and omissions of its direct suppliers, that is the hotel, and not of their staff. Now, on one reading of this, and the way certainly I read it, it seemed to be the Court of Appeal saying you can only recover under the package travel regulations if you can show a failure either on the part of the tour operator or on the part of the hotel itself. What that meant was that if the hotel's cleaners, for example, left a floor like an ice rink, the tour operator would not be liable. And that was something that we had never previously seen before. That's not something that wasn't anyone's understanding of how the regulations worked. We had all previously, prior to the decision in the Court of Appeal, assumed that the hotelier would be liable for the actions of their employees, and so the tour operator. So we were treating, say, cleaners of the hotel as if they were suppliers. The Court of Appeal said, well, that's wrong. Actually, it's only that entity, that legal personality, the hotelier, that the tour operator is liable, which meant that when the hotel's staff did something wrong, you wouldn't be able to recover under the package travel regulation. That was a surprise to most of us. I thought it was wrong and said so at the time, delighted to be smugly proven right now. And I was just saying to James before you came on, actually, that it was interesting that that decision was not relied upon by very many tour operators in their defences, because we all kind of knew that it had to be wrong, because it wasn't what the package travel regulations were there to do. They were supposed to simplify the situation, which meant that a consumer could go against a tour operator in relation to acts and omissions taking place in the hotel abroad. But that was what the majority held. Now, Lord Justice Longmore, for whom I actually have something of a soft spot, because he generally agrees with me and is therefore always right, Lord Justice Longmore was in the minority in the Court of Appeal, and he sensibly held that from a claimant's point of view, an offer to help her navigate the hotel grounds was clearly part of the holiday arrangements. It's clearly something that's being done in furtherance of the package obligations between the parties. And furthermore, because Regulation 15 imposes liability for the acts and omissions of the supplier, whether they occur via an employee or not, that Kuoni ought to be liable for them. So Longmore was saying, well, hang on a minute, this is what Regulation 15 actually does. It renders the tour operator liable for acts and omissions on the part of the supplier, doesn't limit that to say it has to be the supplier itself and cannot be an employee or not. And its intention is to make life easier for a consumer, not harder. So Lord Justice Longmore dissented there. Perhaps encouraged by this, James took the matter to the Supreme Court, thinking, I imagine, that this would be perfectly straightforward and simple. The Supreme Court would say, well, I prefer what Lord Justice Longmore has to say about this. Claim succeeds and we can all go home. Not exactly what happened, as we know. So at this point, ABTA intervenes, perhaps getting an idea that the defence that was being advanced at that point by Kuoni was on the ambitious side, because most commentators had said, well, we just don't think that can be the correct reading of Regulation 15. So ABTA intervene at this point, and they argue for an approach that is somewhere in between the positions of the claimant and the defendant. And what ABTA argue for here is quite an interesting interpretation of Regulation 15, which is that where an employee of a supplier isn't the supplier, if the hotel is not vicariously liable for the acts of the employee, the defence should be engaged. Now, you can see why ABTA wanted to intervene in relation to that, because where the hotelier is not vicariously liable for the acts and omissions of the employee, it means that defendant tour operators are going to have real difficulty in getting an indemnity from the hotelier, because the tour operator is going to be liable to the consumer for acts and omissions that the hotelier is not liable to the tour operator for. So in other words, the hotelier would be able to say to the tour operator, well, I'm not indemnifying you for this because they went off on a frolic of their own. They went off on a criminal act of their own. And we wouldn't be liable for that, and therefore we're not liable to you. Whereas under the reading that Lord Justice Longmore was hoping for, the consumer would be able to recover damages against the tour operator, even in those circumstances where the employee would not be, where the hotelier would not be vicariously liable for the employee. And that would inevitably depend on the applicable foreign law, because vicarious liability in, let's say, Spain is going to govern a Spanish hotelier's relationships with their employees. That, of course, would lead to some difficulty, because it would mean that if that was right, if that position was right, the consumer, in order to succeed against the tour operator, would have to bring evidence that the hotelier was liable for the employee under whatever the applicable foreign law was. And of course, the intention of the regulations is to make life simpler for the consumer and mean that they don't have to bring their claim under foreign law. So there's a tension there between ABTA's position and the intention behind the regulations. But you can see why they argued what they did in circumstances in which pretty much everyone was saying the defence here is on shaky ground. The Supreme Court did not make a determination of that, but referred two questions to the Court of Justice of the European Union. And I imagine that at this point, James would have breathed a sigh of relief, because when it asked those questions, it asked the CJEU to assume that guiding the claimant through the hotel grounds was a service within the holiday arrangements provided by the defendant. So at that point, it became not clear, but there was an indication that the claimant was going to win on that she did fall within Regulation 15. And the only question then was whether or not the defendant kicked in. Let me take a moment, because I've got a question. Could the tour operator not cover the recovery from the hotel through an express contractual indemnity clause? Oh, Chris, you preempt my brilliant idea, which was going to occur towards the end of the webinar. But yes, of course they could. Of course they could. And that is the answer to that objection, that it's unfair on the tour operator because they won't be able to get an indemnity from the hotelier. The answer to that is, well, put in your terms and conditions, then you will get your indemnity. So yes, you are quite right, Chris. That was the answer to that objection. Returning to the slides. So at this point, James and presumably Mrs. X realises that actually they've probably won on Regulation 15, but there is, or on falling within Regulation 15, but there is still this defence to be answered. Can the tour operator bring themselves within the defence that they're not liable for an employee's actions? And the referral reflected that. So there are two questions. First of all, where there's been an improper performance on the part of an employee of a supplier, not a supplier themselves, is there scope for the supplier to raise the defence? And if so, by what criteria should the court determine whether the defence applies? So what they're asking there is, do we look at the law on vicarious liability in relation to the relationships between the supplier and their employees? If we don't look at the applicable law on vicarious liability, how do we judge it? What do we do? Second question, is the employee a supplier of services within the meaning of Regulation 15(2)(c)(2)? So can it be said that the improper performance is something which the other parties to the contract or the supplier of services, i.e. the hotel, could not foresee or forestall? Can you bring that defence when you're talking about an act which is committed by an employee? So two legal questions only. The Court of Justice I think it's a slightly peculiar finding, actually. So they find that an employee is not a supplier directly. So they're not a supplier of services within Regulation 15, but nonetheless, the tour operator still can't raise the defence where the improper performance is due to the acts or omissions of the employee of a supplier. So effectively, although the employee of a supplier is not themselves a supplier, if there has been an improper performance which is due to the acts or omissions of that employee, you can't, as a tour operator, raise the Regulation 15(2)(c) defence. And then it went back to the Supreme Court, and I will let Conor deal with that.
Thanks, Sarah. So yes, having had its answer from the Court of Justice, the Supreme Court went back to consider issue 1. As Sarah's already suggested, I think James probably knew the answer before the Supreme Court got to it. But considering this first issue was guiding Mrs. X to the reception of service within the meaning of holiday arrangements. Remember, the Court of Justice had been told to assume it was. The court looked at Regulation 15, which says the other party to the contract is liable to the consumer for the proper performance of obligations under the contract. The Supreme Court said it was important to have regard to the subject matter. This is a holiday that's supposed to be enjoyable and pleasant. That encourages a broad and inclusive interpretation rather than a narrow one. The Supreme Court adopted, I think, Lord Justice Longmore's view of the matter. This isn't just a question of transport, a mattress and a roof over one's head when one books a holiday. Really, this is a 4-star hotel, and they agreed that when one books a 4-star holiday, one expects, it's common sense to expect that staff will be courteous and provide ancillary services. The examples given were cleaning. Obviously, this was an electrician. I'm not sure if they would go so far as to include provision of electrical services within the meaning of ancillary services. But I think every case always depends on its facts, and I think it's important to remember here that one of the important facts of this case was that it was a finding of fact that the employee, the electrician, actually offered Miss X to guide her to the reception. It's not clear what would have happened if that hadn't been the case, if this had been an electrician who'd simply sort of nipped off on his lunch duty and hadn't been at all involved. So I think there is possibly still some scope for a variety of facts in these cases. So considering whether this electrician was providing a service or a criminal enterprise, well, really one could come to either conclusion. But the view that the Supreme Court took was that because the electrician was only actually able to commit this crime as a result of his purporting to act as a guide to Mrs. X. So the assault really was doing the opposite of providing good service. And for that reason, the Supreme Court thought that the Court of Appeal was wrong, and that guidance to the reception was part of the holiday arrangements. And even if it's only purported, even if an employee is only purporting to carry out those functions, they're held to be doing so regardless of what they actually do in fact.
So I just had a couple of questions. So can I interrupt you and pause there? Question from an anonymous attendee. Do you think if it was a cheap deal, a lower standard is placed on the tour operator and their suppliers? And I imagine that this arises out of the fact that there is reference to the judgment to it being a 4-star hotel. And that seems to have been in their minds at the time. Do you think it makes a difference?
I agree. I picked up on that as well. And, one would have to ask what would have happened if this was a 2-star hotel. Would the court, seriously suggest that there should be a different result? They actually make reference to, I think the Supreme Court says it doesn't matter, but they do also then quote I think it's the hotel's policy or terms of employment. And it said something like, all staff are expected to assist hotel guests and be courteous and so on. If that wasn't a term of their employment or the policy, and if this was a 2-star hotel, could we have had a different result? I'm not sure, James might have some views on that, but I think that is an interesting question. I think there is some scope for distinguishing sort of travel cases with slightly different facts.
I personally, I think it depends upon the service involved. For me, guidance of a lost guest around the resort, I don't think it matters what star the hotel is. Even if it isn't expressed within the house rules, it's implied that staff members will assist a guest in that situation, in my view. But I do think it depends very much on the service.
Yeah, it's quite interesting because back in the day, 20 years ago, I think, was it Holden? I think at first instance in Holden, the judge held that it mattered, that it was a 4-star hotel. And the Court of Appeal said it doesn't matter at all. The star rating doesn't matter at all. This seems to suggest that it may matter in some circumstances, but I guess that's one of the things that will give rise to litigation.
Yeah. No, it's an interesting question. So
one other question, sorry.
Yeah.
Nick Parkinson, the Supreme Court decision suggests as long as the employee that commits a deliberate act was presented the opportunity to do so by virtue of their role as an employee, the tour operator will always be liable. For example, if a hotel employee one day committed a terrorist act during work hours, the tour operator would be liable. Do you agree? This is a question about the fact that the employee has been given the opportunity by virtue of the fact that they are working at the hotel. So I guess if a person, let's say they committed a terrorist act, but they could have walked in off the street and committed a terrorist act, it wouldn't have anything to do with their employment. But let's say the only reason they were able to get into the hotel was because they were an employee. Would that then give rise to liability on the part of the tour operator?
No, it wouldn't. It depends upon the service, doesn't it? What service is contracted for it's being provided at the time. Just as an employee is there doesn't mean that they commit a criminal act. The key in this case is the service was being provided at the time the criminal act was taking place. So no, I don't think that would give rise to liability.
Sure. And the same point's just been made, literally just been made by Christine Boosfield as well. So good. It's nice to see you and Christine agreeing about something. And if you two agree about something, then it must be right. I'd hazard to guess that I agree with that as well. Sorry to interrupt you, Conor.
No, that's fine.
There's another question as well, which I will, or we will answer a little bit later. So be patient.
Yeah, I think there's going to be a lot of finely balanced cases that could go either way. But I think the overarching sort of guidance from the Court of Justice and also from the Supreme Court is that just standing back and looking at the purpose of this approach, it's really about consumer protection and, not leaving consumers in the lurch. So if there is any doubt, I think it's going to be resolved in favour of the consumer, given this judgment. So yeah, as I was saying, the Court of Justice wasn't actually asked about issue 1, but it kind of nevertheless commented on it, and the Supreme Court took support from that. What we were just talking about, this high level of consumer protection, it cannot be interpreted restrictively, and that obligations comprise all obligations associated with a holiday. So going on to issue 2 then, this was the issue that the Court of Justice was in fact asked about. Can liability be excluded by Regulation 15.2? Again, as Sarah said, the Court of Justice said that an employee isn't a supplier of services himself. That's just, I think it's got to be right, given that employees are in a sort of subordinate relationship, is the term used. They don't contract directly with the tour operator, but of course that didn't matter because going back to this objective of ensuring a high level of consumer protection, these exemptions had to be interpreted very strictly and narrowly, and therefore organisers are liable unless the failure to perform contractual obligations is attributable neither to the fault of the organiser nor of the supplier. That sounds like it might not be clear, but what they said, what the Court of Justice said at paragraph 61 of its judgment was, it's quite an interesting statement. Since the acts or omissions of an employee of a supplier fall within the sphere of the supplier's control, those acts or omissions cannot be regarded as events which cannot be seen or forestalled within the meaning of 5.2c. So what the Court of Justice was saying there is that because the employee was within the sphere of control of the employer, even this terrible act that he did couldn't be regarded as something which cannot be foreseen or forestalled. So it really treats the employee as an extension of the supplier, whatever they do, provided that it is in the performance of the obligations under the holiday contract. So I thought that was quite an interesting and very important interpretation. So summing that all up, the Supreme Court has taken a broad view of the scope of obligations, and that was supported by the Court of Justice's analysis of the directive, its objective in achieving harmonisation, as I think Sarah mentioned, sort of simple, affordable, accessible remedy for holidaymakers when the holiday they booked falls short of the standards that they can expect. And the Court of Justice took a very narrow view, for the same reasons, of the exemptions under 15(2). And of course, the Supreme Court was bound to accept those that view of the Court of Justice. Finishing then on vicarious liability not being an issue. Again, this comes back, I think, well, the court has said it comes back to the objective of the directive, which is not requiring consumers to get involved in the difficult and various issues across 30, however many member states, different laws of vicarious liability. It's just going to add expense, variety of standards, and it goes against everything that EU law in this area is seeking to achieve.
Yeah, I agree with that, Conor, for what it's worth. A couple more questions. First of all, on the line, it's difficult to draw the line on when a service is being provided. So this question from Chris Deacon at Stewart's. Take the example, he says, admittedly extreme, of a hotel porter who is on duty providing services to guests pursuant to his contract of employment with the hotel. Okay, so no problem there. If you've got a hotel porter who's on duty, he is providing services under the package travel contract, fine. By virtue of being in the hotel lobby, conducting his duties, he then opens fire on guests in a terrorist attack. Now, it seems to me that liability would follow there, wouldn't it? Because he's conducting his services at the time that he then starts doing the criminal act that causes the problem. So Chris says, I'm not sure it follows there'd be no liability under X and Kuoni. Well, I agree with you, because at some point, the employee stopped providing a service and started to commit a criminal act. And the same goes for the hotel porter in this example. And I agree with you, Chris. And this actually is an area where I have real difficulty with vicarious liability. And I may as well confess that now, where vicarious liability for criminal acts is really difficult, because at some point, and this is not vicarious liability, but it's the same problem arises, where you've got to show that the employee is undertaking his services, but at some point he steps outside them to do something which is wholly not what he was employed for. But do we think, and James, do you think it's that the test is, were they given the opportunity by virtue of their employment, or is there a different test?
I agree it's a difficult line to draw. I think the key in Chris's example there is that the porter was conducting his duties and therefore was providing the services, you say, Sarah, so I agree entirely with what you've said. I think it's going to be fact. I think every case is going to be fact specific, to be honest. As Conor rightly pointed out, the purpose of this judgment is to re-emphasise, and as you said at the beginning, it's a clarification rather than a revolution. Consumer protection is at the heart of the directive and heart of the regulations, and therefore there needs to be a view taken of cases like this on the side of liability rather than the side of the defence. So I think that's what I'd say in terms of looking at each individual case.
Sure. And the other question, maybe one for you, Conor, what do you think the conclusion would have been if the electrician was a contractor and not an employee? So if it was an independent subcontractor, which would be a defence within domestic law, so the hotelier subcontracted with an independent subcontractor to come in and provide these services. Let's say he was an electrician who was not employed by the hotel, but was a totally independent subcontractor, comes onto the hotel grounds in order to provide these services and then offers to show her around the hotel. Does that make a difference?
I don't think it would have made any difference. And actually, I think it's paragraph 42 of the judgment deals with this. And I think, yeah, the Court of Justice made the point that if we make a distinction between employees for which, you know, someone's liable or not liable, and suppliers, and if we distinguish that, that's an arbitrary and unjustified distinction. And what, of course, that would lead to inevitably is, you know, very acrobatic sort of contractual contortions whereby tour operators and hotel suppliers attempt to cast what is plainly an employer or supplier relationship as something else. So I think the point that the Supreme Court makes, it deals with paragraph 42, and it says, look, this is an unjustified and undesirable distinction.
Okay, question from Nick Parkinson. Can you provide some examples where an employee commits a deliberate act at the hotel during work hours, not on his or her lunch, but you think would not give rise to liability? So a deliberate act committed in the location and within work hours that wouldn't give rise to liability. I can think of one example, which would be where the employee is doing something which is completely outside the services that they're providing. So, I don't know, you might have a chef at the hotel who, I don't know, no, that doesn't work. I think it's, sorry, go on.
I was trying to say it's difficult. I agree. It's a difficult distinction.
I think it would have to be something where he is supposed to be in a certain area of the grounds and then goes to a completely different area of the grounds and does something totally different. So in no way is the act that he commits linked with the thing that he's there to do, there at the hotel to do. But the range of factual nexuses in these cases is absolutely infinite. So I would never say never.
It doesn't depend.
Okay, Chris Deegan has an idea.
Yeah.
Hotel receptionist failing to save someone drowning in the pool. Yeah, that's a really good example, actually. It's an example of someone who is there to be a receptionist, is not there to be a lifeguard, and who fails to do something that a lifeguard would owe a duty to do. That might be a good example. And actually failing to rescue is one of those areas where liability is quite grey, because we don't owe a duty to rescue, or most employees will not owe a duty to rescue. A lifeguard would, but a receptionist wouldn't. So that might be, yeah, that might be one. Although if I were for the claimant in that case, I would be arguing the contrary to that.
I think the way you'd have to plead that would be something along the lines of it was an implied and necessary obligation to provide a lifeguard, rather than focusing on a receptionist who no one would expect to be able to rescue someone.
Yeah. Okay, let's take a canter through a look at the differences now between the 92 regs and the 2018 regs. Because of course this case has been going on for so long that we've actually replaced our regulations now. So we've got different regulations. And you can see there we've put the two different provisions up from the Regulation 15 provision. So the old regulation, the other parties of the contract liable to the consumer for the proper performance of the obligations under the contract, irrespective of whether they are to be performed by that other party or by other suppliers of services, has become the organiser is liable for the performance of the travel services included in the package travel contract, irrespective of whether those services are to be performed by the organiser or by other travel service providers. Now, for what it's worth, and I don't know whether you agree or not, Conor, I think, if anything, the new one is slightly broader than the old one. So I think X and Kuoni is still good law in relation to whether or not Mrs. X would fall within the 2018 as she did within the 1992.
Yeah, no, I completely agree. I think the purpose of this legislation is still the same. The same sort of broad and strict interpretations are going to apply to the liability and the exceptions.
Well, the exceptions, I think, are slightly different, because I think there's more of a difference between the exceptions. So let's have a look. So the first one, and it doesn't help that they're enormously long, but the first one, the old one, which this case was X and Kuoni was heard under, liable to the consumer for any damage caused unless the failure of improper performance is due neither to fault on the other party nor to that of another supplier of services, because they're due to an event which the other party or the supplier even with all due care, couldn't foresee or forestall. And we know that that's disjunctive now. That has become, the traveller is not entitled to compensation for damages if the organiser proves the lack of conformity is attributable to a third party unconnected with the provision of the travel services included in the package travel contract. And, so that's subjunctive, is unforeseeable or unavoidable. Now, I think that change in wording has made matters worse for tour operators. I think that is a more difficult hurdle to get over, but I'd be interested to know what you think. Silence. I'm taking silence for assent. Yeah, okay, good. I think that is...
Was that a question for me or for the audience?
It was a question for you, actually, Conor. And James,
sorry.
But you just sounded like why.
Yeah, so... no, sorry. No, I completely agree. I think it is. It's impossible. Well, it's very. I can't imagine a factual scenario where where a tour operator would get out of this. I mean, a third party unconnected with the provision of the travel services. I mean, any kind of employer or supplier is going to be connected, and then it has to be and also unforeseeable or unavoidable. And of course,
that deals with the subcontractor point as well, doesn't it?
Yeah.
Because it's absolutely clear that a subcontractor would fall within that if they are actually providing the services.
Yeah, and going back to what the Court of Justice said in paragraph, I think it was 61, about essentially nothing that an employee does can be unforeseeable or unavoidable. I think you're right, Sarah. I think it is much more difficult. Well, it's certainly no easier for a tour operator to escape liability.
Okay, I'm assuming you agree, James, because you were nodding. So
yes, unsurprisingly, I agree. Yes.
Now, the other thing that I was quite interested in, and I know I'm conscious of the fact that we've got a limited amount of time, but I was quite interested in how this dovetails with these recent cases on the hire duty owed by hoteliers. And Al Najjar is quite an interesting one because that is a deliberate act where the assailant comes into the hotel, isn't challenged by the concierge, walks past the concierge, goes up to the upper floors. The claimants have left their doors unlocked. He goes in and starts rifling through their belongings, stealing their stuff. One or two of them wake up. He attacks them, causing some really, really significant life-changing injuries. And there is a suggestion in Al Najjar, which is also echoed in the White Line and James one, which is the guy smoking and falling out the window. There's a suggestion that there is a higher duty on hoteliers than on other occupiers of premises. And I just wonder whether we are coming towards not a strict liability, but a stricter liability on hoteliers domestically in these cases, but also internationally under the package travel regulations, and whether construing the 1992 regs and the 2018 regs in the way that Ex and Kuoni was construed, whether that's all part of a pattern of judges saying, well, look, if you invite guests to your premises, they need to be safe. So, for example, in Al Najjar, there was talk about CCTV and so on, and it was held at first instance in Al Najjar and indeed upheld in the Court of Appeal that there's no duty to provide CCTV in hotels, generally speaking. I wonder whether that's going to be followed in relation to some foreign hotels where we know there are certain areas. I'm doing a deliberate act case at the moment, actually, in Ayia Napa, where there is specific legislation locally about not allowing people up to the upper floors of the hotel because there's such a problem with assaults. And I just wonder whether in some jurisdictions there are higher duties on hotels in particular. So whether there's a higher duty, whether it's all effectively bad news to tour operators at the moment is effectively what I'm asking. What do you think? Do you feel that there's a sort of movement in the particular higher courts towards imposing duty in these cases?
Yeah, well, I think it comes down to what services are impliedly included within to be provided under a contract with the hotel or the tour operator. I think in the case we've been looking at, in Kuoni, it was a very easy one because obviously guiding people and helping people will always be an impliedly included term of a contract, courteous treatment. I think in the Najjar, I suppose having a sort of hotel receptionist to provide not a 24-hour watch, I think is what the court said, but some level of sort of supervision and monitoring So I think that's what it comes down to. I'd say maybe in this country, for domestic cases, you probably don't have that sort of presumption almost in favor of the consumer. But I think they do share that feature, that it's about looking at what services should a hotel be expected to impliedly include.
Sure. And then moving on to the Athens and Montreal Conventions, we had a question about this from Darius. I'm delighted to be back to answering questions from Darius as to whether or not Ex and Kuoni actually has an effect in Athens and Montreal cases. I don't think it does, actually. I don't think it affects Athens and Montreal because they're standalone conventions. But what I would say is it is the Supreme Court indicating that in holiday type cases, you protect the consumer. But Athens and Montreal, because they are standalone conventions and they are drafted with particular balance between consumers and providers in mind, I don't think it can affect them. I'm looking at Conor who's nodding, which is
no, I agree with that. I think the whole point about Athens and Montreal is, it's about certainty, and sometimes you win as a passenger, sometimes you lose. But the point is, it all comes out in the wash, and you know what you're going to get. Whereas that's not the purpose. That's not the kind of thinking behind EU regulation, which is very much pro-consumer.
Yeah, James, do you have anything to add to that, or do you agree with that?
Not really. They're standalone conventions, as you say, Sarah.
Okay, so, and this is one where, James, I think we want your input really particularly. Where does this leave claimants? I mean, I think it means that you need to be, when people are walking through the door and they have a deliberate act case, you can look at them more favourably than perhaps you would have done before because they're more likely to win. And in all cases, not just deliberate act cases, you're looking at the Regulation 15 duty in a broad scope way, and the Regulation 16 defences have really been closed down quite narrowly. So that would be my feeling. This is good for claimants.
Yes, definitely. Definitely. I expect a wave of admissions now, Sarah, coming through the door. So we'll see.
Yeah, I mean, I think there will be cases where this knocks them on the head, actually, I would have thought. Okay, we've got a question from Will Wilson. Under the 2018 regulations, could the organiser be liable for an assault on one guest by another guest with whom they have no previous relationship? My instinctive answer to that is to say no, because that is a person who has no connection with the package between the tour operator and the guest in question, the victim guest. So I think you'd be okay in your defences there. And actually, I don't think, you don't even get that far, do you? Because it's not an improper performance or a failure to perform the package contract, unless there is some reason to believe that the attacking guest is going to do that. So let's say you have got a drunk guest who the porter knows is drunk, but they fail to do anything about them, let them just maraud around the place. Any views on that?
Yeah, I think if the only situation I can think of would be if there's a hotel bar with drunk people, which are going to be the majority of these situations, and guests on occasion get rowdy and there's no security, then that's a kind of service that you would expect, certainly a 4-star hotel to provide competently.
Yeah, I mean, Christine's saying again, helpfully, outside the sphere of control, and actually you can't, unless there is some particular feature about it, another guest is going to be outside the control of the hotel.
Is it fact specific, Sarah? Again, though, it depends upon the exact situation. Say, for instance, there's a very large resort where there's some form of bar nightclub with bouncers, and there's trouble between guests beforehand. One guest is ejected, but then is allowed back in and assaults another guest. That's a service, isn't it? Yeah.
And Laura Woodfine-Jones is saying a twist on this question, and I don't know the answer to this. What about an organised tour where the tour operator partners you in a room with the other guest who goes on to attack you? Might that give rise to liability? Not rhetorical, actual, genuine. Is it, well, only if that can be viewed as being a failure to perform or an improper performance of the contract, I think. You might not, as a tour operator, I think you'd have difficulty making out Regulation 16 defence because it's not unconnected with the provision of the tour. But you might not get that far because you might be able to say, well, this is not a failure to perform or improper performance of the package contract because it's not, we gave you a room and we gave you a roommate. What service have we failed to provide you with? But that's the difficult one. That's much more borderline, I'd have thought.
Yeah, I don't think that would succeed, but yeah, I agree, very difficult.
And that's an interesting one. So what can we do for defendants? And James, this is something that I want you to answer really, because you've got the inside track. You're the man who can tell defendants what they should do to prevent you from bringing these claims. A few thoughts from me and from Conor. Urgent reviews, obviously, of outstanding cases. And obviously any cases such as these, you need to look at whether or not you need to be settling them or not. Terms and conditions in order to define the scope of the package contract. It may be that services can be excluded under the terms and conditions, but bear in mind you'd have to do that commensurately with the unfair contract terms regulation. So that would not be easy, because if it otherwise does come within the scope of the services and facilities contracted for, you're not going to be able to contract out of it simply by saying, by the way, this doesn't include us showing you around the grounds, because that would clearly be unfair. Should hotels be audited with potential liability for deliberate acts in mind? This is a question that we were asked. And it's a question of what can tour operators do to prevent this stuff from happening in the first place? Should they be auditing to say, you know, is there CCTV? Is there a concierge service? Are people trained properly? The problem with that is that in Kuoni itself, there was no suggestion that the tour operator was at fault. So even, or the hotelier. So even if the tour operator had audited, I don't know whether they did or not, they may well have audited the hotel to an incredibly good standard, they still would not have identified this as being a risk, because this is something that the hotelier did not foresee and had no reason to foresee. So actually auditing, improved auditing, is actually not going to help you with these cases. It will help you some of them, you know, where, and I don't know whether tour operators audit with, within mind, asking hoteliers, you know, are your employees all checked, all criminal records checked or not? I slightly suspect they don't ask that question. But from this, following on from Kuoni, maybe that would be a good idea, because that could give rise then to freestanding liability on the part of the tour operator for not checking. But I actually don't think there's much that tour operators can do, except this last paragraph, which is the thing that I've been banging on about for years. And actually, they've no one to blame but themselves if they're not already doing this, because I've been telling them to check your supply contract terms and conditions, because there is now an increased scope of the duty. And there will be situations where the suppliers themselves would not be liable under their own applicable law, where the tour operators are going to be liable, because the suppliers would not be vicariously liable for the acts and omissions of their employees under their applicable law. But nevertheless, the tour operator is going to be liable in any event. And I think defendants need to look at their supply contract terms and conditions with a degree of urgency and make sure their indemnities are fully in place. But James, what else can they do? What could they have done to defeat you in this case? Now that it's all over, you can say.
I'm not sure there is much they could have done to defeat us in this case. It's a service which is clear, is it not? Guiding around a hotel. It's not. This isn't an obscure case. We've just been trying to go through examples there of obscure factual scenarios. That wasn't this case. In terms of moving forward, in terms of your bullet points there, organisers should be conducting urgent reviews of outstanding cases. Definitely. As I said, I expect a lot of admissions. Terms and conditions, I agree with what you said. So I think it's very, very difficult to contract out of liability in cases like this. And then, as Chris said earlier on, sort out your indemnities with your suppliers. I'm not in the business of advising tour operators, but if I was, that would be the advice I would give. And I'm sure there's many people on this call now that are much more experienced in advising tour operators and will be doing the same thing.
It's just interesting to get it from the other side of the fence. Comment from Jeff Moore, who actually provides these services, and he's providing a comment saying that hotels are notorious for not providing effective security because security is a cost centre, and they're not too enthusiastic about it generally. If they provided a bit more security, including better background checks and more CCTV, a lot of these incidents wouldn't happen. And actually, do you know, maybe we're all getting too involved in the legal aspects of this. So maybe we need to stand back and say, well, to prevent legal claims happening in the first place, prevent these things from happening at all in the first place. And it may be that hotels providing better security in the first place might be the answer to it. We're not talking about defeating claims. We're talking about preventing the incidents that give rise to them. And actually, I think we can all agree that that's something that is desirable, whether you're a tour operator or claim solicitor or whoever it may be. So yeah, I mean, better provision of hotel security. I think there's a really good point actually there, Jeff. And he's suggesting using a hotel violence database as an intelligence tool. And actually that's, in some ways, if you're a tour operator, you actually don't want to know if your hotel's got a real problem with hotel violence, because if you do, you're fixed with that knowledge. So then you become liable yourself for your failure to perform. But actually, would it help if we knew? I mean, we all know who the problem units are for, let's say, food poisoning, don't we? Maybe there are similar problem units with deliberate act problems. There are certainly particular problem destinations that I can think of, where we send people to these destinations and there is a problem with violence there, including violence undertaken by hotel staff. So maybe actually maybe that is the answer, is for tour operators not just to be defensive about this, but also proactive in terms of looking at which hotels are the problem units. And as far as I know, and I'm sure that somebody will tell me if I'm wrong about this, that's not actually something that features in tour operators' thinking in relation to places they send their consumers to. Maybe it should.
Yeah, that's an interesting solution. I just wonder if you'd have to be quite careful of GDPR sort of implications of holding data on individuals on a large scale. But yeah, very interesting thought.
Well, we hold things like accident report books, don't we?
Yeah. No, definitely worth looking into. I just think it's something you've got to sort of be very careful about. Yeah.
Okay, so any thoughts, ask someone, on the application of Regulation 16.4c, unavoidable and extraordinary circumstances in deliberate criminal act cases? That's an interesting question. I think the answer is it's not unavoidable if it's something that has been done by a hotel employee. Probably not extraordinary either. But what do you think, Conor?
Sorry, I missed this question. What was that again, Sarah?
Any thoughts? Sorry, we're wandering off. Bear with us.
No, is this Jatinder Paul's question? I was reading.
Any thoughts on the application of the other defence, the unavoidable and extraordinary circumstances defence? Would that work if it's a deliberate act undertaken by an employee? I don't think it would, but I've never tried it.
Unavoidable. I don't know. It's very difficult. I mean, I think what the Court of Justice said about everything the employee does being within the sphere of control of the employer means it's very difficult now to sort of go anywhere with that as a defendant.
Yeah, I agree.
Yeah, I agree. I think that application is going to be across the board, across all of the defences.
That certainly makes sense to me. So you were looking, Conor, so now I'm going to ask you, because you're looking at this question, the question that Jat asked, in a swimming pool crypto case, what about defendants using X and Kuoni being used as a defence by saying that the hotel contracted out water treatment, but they failed? Okay, so they're using an independent subcontractor.
Okay.
Is that going to work, do you think?
So if they contracted out water treatment, yeah, I think it doesn't matter if they contract it out or if they do it by, oh, it's disappeared. I think that question's disappeared. It doesn't matter if they've contracted it out or not. I mean, providing clean water is even more so, I would say, an implied and necessary incident of a holiday contract. And if the supplier can't provide, supplier or employee, it doesn't matter. If they can't provide clean water, then I think they're on the hook for that.
And then lastly, from Nick Parkinson, do we think this decision provides claimants and defendants more with clarity or ambiguity? Has it helped or hindered, do we think?
I think it's helped. I think it's clear now. I mean, it's not good for defendant, but at least it's clear.
I imagine, James, you would echo that.
Yeah, yes, definitely. Yeah, it's as I said. I think you said it at the beginning, Sarah, and I said it as well. This is a clarification of the law. Everybody knew this really already, but now it's very, very clear to everybody.
I think it's provided clarification on how the regulations are likely to be interpreted. I actually find it quite hard to get my head around this idea that an employee is not a supplier, but nevertheless the tour operator is liable for them anyway. I find that quite difficult. And I'm not with the greatest respect to them, I'm not completely sure the Supreme Court dealt with that, gave that argument the respect or attention that it deserved. So I agree with you generally. I think it is a clarification. I think it puts right something that was probably wrong in the Court of Appeal. But I'm slightly confused as to how an employee is not a supplier, but you're still liable for them all the same. So I think that's slightly odd, but
yeah, I agree. I thought that was a really remarkable part of the judgment.
Yeah, I think it is too. Now I was going to create a poll, but I actually, oh, there we are, untitled question. Here I have no idea how to do this. Is the decision right? Is the decision right? There we go. Option. Then we can answer. It's just the front. Oh, that's my phone. Sorry. Yes or no? Right. Okay. Is the decision right? Launch. Now, do you all have a poll on your screens now? Oh, you do? I can see.
Yes, yeah.
I mean, this obviously seamlessly and well planned as usual. Emma's going to be very cross. There's quite. Do you know what? There's quite a split of opinion here. More perhaps than I had thought. You guys are seeing this, presumably.
Yeah, I can see it. Yeah.
Okay, we're still getting answers. I'll just give it another little minute if you want to vote, just to see what you make of it all. And it really is a question of, do you think it's right in law, as opposed to, do you wish it was different? There we go. I would share it with you all. I don't know whether I am sharing it with you all in any event, if I knew how to do that, but of course I don't. There we go. So 71% think that the decision is right. 29% think it's wrong. Be quite interested to know, there you are, sharing results. Be quite interested to know why you think it's wrong. Because for what it's worth, I think it's probably right, with that caveat that I think there's a slight tension there between whether employees are suppliers or not and whether you're liable for them. So yeah, I'd be quite interested to know why that's come out in the way that it has. Sorry, Laura, I can see that you're raising your hand, but I don't know how to respond to that. So put in the chat or in the Q&A anything that you may feel about that. We have, as I suspected we might, gone over by 5 minutes, but I would just be interested in views on why we think it's wrong, whether we think we can alter it or gloss it or change it in the future, because I think it probably is the final word on deliberate acts in this context for some time. I can't see anyone else having an appetite to take a deliberate act case up to the Supreme Court for some considerable time to come, particularly given how long it's taken. But any further questions? James, I'm holding on to you for as long as I can. You, having volunteered to come along and talk today, I'm afraid you put yourself in the hot seat. But
my pleasure.
Okay, well, it just remains to thank you, James, for coming along and giving us the benefits of your experience on this one, and even for putting up with me asking you how to help defendants, which really does go beyond the call of duty. We're very grateful.
Absolutely my pleasure. Thank you for inviting me.
Oh, you're very welcome. As always, the webinars are every 2 weeks. 19th of August, which is not next week, the week after. In the next in a series of Sarah Prager and Friends, our special guest will be Chris Deacon of Stewart's Law, who will be discussing how to get the most out of your barrister. Tempting to make it a rant on not instructing us at the last minute. I think you can probably take that as read. Also, a plea for paying us more might be a good way to get more out of us. I don't know. But in all seriousness, there will be a number of practical tips, things that you can help us with so that we can help you as well. And of course, there will be a discussion between Chris and me as to how to get the most out of your solicitor as well. What you want from barristers, what we would like to have from you as well. So hopefully you can join us then. But lovely to see so many people, and nice to have a nicely interactive discussion as well. It's obviously something which is giving rise to a little bit of angst through the industry, if I can say that.